standardized OTC derivatives should be traded on organized venues in order to enhance the transparency of those markets and those products being traded. So Mifid II has essentially come out of that G20 mandate, which obviously has also spawned Emir. It's spawned Dodd-Frank in the US. Mifid is part of the EU response, effectively covering the execution and trading landscape, whilst Emir covers the clearing and trade reporting landscape. That said, whilst the push was clearly from that G20 mandate, there was in the initial Mifid regulation an intention to review the outcomes and potentially look at expanding its provisions across a broader range of asset classes in any case. So together, this combination of credit crisis and reaction to credit crisis, along with this sort of already stated intention to look at Mifid and whether its outcomes have been successful, has led to this package of regulation that is now being termed Mifid II. Mifid II is actually comprised of two distinct pieces of regulation. One is a recast directive, so essentially taking the original directive that came into force in 2007 and amending that to have a broader impact on the market. And then secondly, a new regulation. So unlike a directive, a regulation comes into force directly without any need to be transposed or interpreted at individual state levels. So essentially preventing any sort of national inconsistency or inconsistency across national boundaries of interpretation. So this regulation effectively brings in a whole raft of new requirements to supplement the original Mifid and the amendments that are subsequently being made. So what are the objectives? Unsurprisingly, the 5 objectives we've got there on the right of the screen really speak to a need for greater transparency within financial markets and across financial products as a whole. There was certainly a feeling post-credit crisis that this lack of transparency, certainly in the derivatives market, had harmed risk management processes, had harmed the overall understanding of counterparty positions and so on. So one of the primary goals is certainly more robust and efficient market structures that drive transparency into the market.
Sorry, Matt.
I think just to explain very briefly to sum up the context and the objectives here for Mifid II. It's come out of the G20 mandate. It's also come out of a commitment to review the outcomes of Mifid I. Fundamentally, it aims to drive more efficiency and transparency into the market. It also looks to take account of technological innovations. That's quite significant given some of the issues and the high-profile nature of algorithmic trading at the moment. The original Mifid didn't really take any account or take into consideration the advances that were being made in trading technology. Mifid II seeks to do that. Where commodity derivatives are concerned, it also provides for more interventionist, and this is quite an interesting and perhaps concerning precedent. It provides for more direct intervention from the regulator in terms of the size of positions that are being held in commodity derivatives. And lastly, again, given all the sort of furore around bank conduct and the conduct of financial services providers at present, it also looks to enforce stronger investor protection requirements on financial services institutions, particularly those institutions who are in the business of selling both packaged investment products and structured deposits, and also who are in the business of providing investment advice and discretionary asset management. So, that sort of objective, again, is a fundamental and sustaining requirement throughout the Mifid II regulation or package of regulation. So again, the overview, how does it work? As I said, the original Mifid focused primarily on the equities markets, or the effect was that it focused on equity markets. Mifid II expands this across into the fixed income world, and also, given the mandate to enhance transparency around OTC derivatives, certainly into that space as well. Effectively, it can be distilled into 7 components. The investor protection business conduct standards that, again, I talked about stronger investor protection. We've seen business conduct and business conduct standards being a prominent feature of regulation, both in the States and in Europe. In other regulatory initiatives, that's mirrored certainly in Mifid II. Algo trading requirements around those technological innovations, those advancements in trading technology. Pre-trade transparency, so the ability to, or seeking to enhance or expand the perceived access or fair access to prices in the market, ensuring that all have the same access. Market structure and execution, changing the way that current market structure operates, introducing some new types of execution venue. Post-trade transparency really speaks to the publication of trade data in the immediate aftermath of a trade being executed. Position management, as I've already noted, and interventionist powers in relation to commodity derivatives. And then, again, as with Emir, but not overlapping with Emir, there are transaction reporting requirements. So transaction reports that were in place under the original Mifid are now being enhanced to capture some additional fields. And then there are 2 other requirements, or sort of buckets of requirements, if you like, that are broader and that need to be addressed at the entity level. Those are around organizational governance, so the makeup of senior management, the criteria that senior management bodies must meet to be accepted as, or accepted into those roles. And then third country access and supervisory powers, the ability to effectively passport into the EU from outside of the EU, and how firms are doing that and how firms have sought to do that, again, is under the microscope and is changing the nature of cross-border business, certainly, as I say, from outside of the EU into the EU. And again, that has sort of real connotations for booking models that global investment banks operate. So that's basically how it's distilled down. The next slide here, which hopefully you can all see, then breaks that down really on a front to back basis. And I'll just go into a little bit more detail here about some of the actual requirements. So at the front end, we talked about investor protection. From a client servicing perspective, there are now enhanced disclosure requirements, whereas before, certainly where professional counterparties and eligible counterparties were concerned, the level of documentation required was pretty slim. That's now being enhanced significantly. And also where retail clients are concerned, and I talked earlier about the sale of structured products and structured investment products, or packaged investment products, if you like, for retail clients. There is a tightening of the product scope for what's included there. Anything now that embeds a derivative as a retail investment product has enhanced disclosure requirements around it, so a lot more for firms to do in how they interact with their client prior to the sale of any investment products. You know, again, in terms of disclosure requirements, in terms of record keeping, that's going to sort of enhance the operational burden for those firms. Algorithmic trading, you know, some firms have said that the Mifid II is going to clamp down on algorithmic trading to the extent that it no longer really becomes a viable way of, or a means of accessing the market. I think that probably goes a little bit too far, but certainly there is a great deal for firms to do in terms of providing regulators with details of their testing procedures for the algorithms that they use, where they use algorithms to fulfill market-making obligations. Essentially, they can't pull those algorithms as soon as markets get volatile. They have to provide predictable and sustainable liquidity on venues, which again sort of ties firms into a greater commitment than was there before, and leaves them open, or in their perception leaves them open to exploitation in volatile markets. And also, you know, services like direct market access again are becoming much more tightly controlled, and the onus is going to fall on those firms providing direct market access to tighten the scrutiny of the clients to whom they're providing that access, so ensuring that those clients are not able to put rogue algorithms into the market and effectively use the bank's infrastructure on a DMA basis. Pricing and execution, I think certainly the most high-profile issue here is the introduction of a trading mandate for certain standardized OTC derivatives. So again, this general push to electronic marketplaces, the increased electronification of derivatives markets, meaning that, you know, we've talked about under Emir the enhanced sort of futurization of the swaps market. I think Mifid II certainly supports that, because we are going down a much more standardized route, taking that level of sort of bespoke product development or product structuring out of the market, and I think that will certainly be significant for firms. Post-trade, the requirement to publish in as near real time as possible details of the price, volume, and size of the trade. Again, clearly in the fixed income world, the issue here is that where products are less liquid, if you are, and you know, as a market maker, you may have taken a risk position. If you're having to make public the details of that position in as near, you know, close to real time, then you're leaving yourselves exposed in terms of how you want to hedge that position through a period of time. So again, there are issues to work through there. Position management. So, you know, the concern here is that, as I said, the increasingly interventionist powers of regulators to be able to effectively put limits on positions that firms can hold in certain commodity derivatives. You know, it's important to say that that's very much focused on speculative market activity. They're trying to cut down on proprietary positions in the market where you can, you know, demonstrate that effectively you're hedging a clear risk. Then those position limits aren't going to apply to you, but it is going to cut down any speculative or proprietary trading in commodity derivatives. Clearing, there's a clear interaction and overlap with Emir here. It's basically opening up the whole clearing environment. So trading venues are to allow or to provide non-discriminatory access to the clearing environment. So whereas before you had execution venues clearly tied to certain clearing houses, that is now going to be opened up, although the caveat there is that that's not coming in immediately. There is going to be a 2.5-year delay while the market essentially, while ESMA essentially tries to define how that will work in practice. So there is a pause on that one. And then transaction reporting, as I said, new fields really in terms of whether a trade is a short sale, whether there's an algorithm being used. So again, increased data capture requirements and reporting requirements there at the back end of the trade life cycle. So it really is a pervasive piece of regulation. It's going to impact front to back. It's going to drive significant upheaval on an operational level, and I think those sorts of impacts are now starting to filter through to firms as they start to try and understand, okay, how do we actually put this into practice? What do I need to do in terms of certainly the execution and post-trade world to try and capture all of the necessary data, to record and keep all of the necessary data to ensure that I'm compliant with Mifid II. Lastly, in terms of the process, the reason that this is now sort of coming to the fore is that in April there was an agreement, or the agreement announced at EU level to say that the basic principles, the level 1 text had been agreed upon. That is now going into the European or the EU rulebook. However, it won't become live until they've defined all of the technical standards that are actually going to make those principles work in terms of the operational environment. So what we're about to go through is a whole raft of consultations coming down from ESMA on numerous different technical standards and rules, from how they calibrate the pre-trade transparency requirements across different products, to how these algorithmic management requirements are going to play out, and also, again, in that post-trade world, where there will be exceptions for post-trade reporting given size and liquidity of products or positions. So we're still probably 2.5 years away from this actually being implemented. That's not to say that it's not going to cause a significant amount of work, certainly as we move into 2015, when those technical details are much clearer. We've got more clarity on what the actual implementing rules are going to be, and I think that's going to drive a great deal of work for both global financial institutions, but also some of the smaller players in the wealth space, and even this even expands out into the insurance world as well. So it's something that's going to be a sort of strong theme over the next 18 months, and one that is going to cause a large amount of upheaval for a great number of market participants.
Okay, Matt, is that about done yet? Okay. Thank you very much for that. I know you're on a pretty tight time scale. Just one question that sort of has come through. So will companies have to do transaction reporting if they're already reporting under Emir?
No. So where there is, there's no dual reporting effectively. So where that report is issued under Emir, they're effectively going to the same trade repositories. They're called approved reporting mechanisms under Mifid. They will be the same trade repositories. If you're reporting under Emir, you won't need to do that for Mifid II. The same trade won't need to be reported twice. Okay,
bit of a relief there then. And in terms of the product scope, is that the same as Emir?
So it is, well, in theory it is. There is still an open question with ESMA in terms of determining the scope of derivatives captured under this, under Mifid II. The original Mifid actually set or is used as the benchmark for defining products eligible or impacted by Emir. There was hope that Mifid II would start to clear up some of the confusion around things like physical forwards in the energy space. It's not done that at the current stage. It's with ESMA to try and define and become a little bit clearer. You know, broadly speaking, it is the same, but there will be important caveats, and those are part of the details that we're going to see emerge in the next, I guess, 12 to 18 months.
Okay, lovely. Well, look, really appreciate your time, and I know you've got a prior engagement, so we'll let you get off. Thank you very much again. Okay, Collette, I will transfer over to you now and make you the presenter so you can continue on. Thank you for letting Matt do his bit before he had to head off. Should be able to see your screen. Yeah, okay, you're good to go.
Okay, you can see an updated screen here. So the Emir core principles are separated into three, which is central clearing, reporting, and risk mitigation. So here, yeah, just checking it's still connected. So where we are on them now, risk mitigation is broadly mainly implemented by people and has been for a while. Reporting, this is the most recently implemented, which most everyone will have gone live with recently on the 12th of February, but we've got further steps to come. And then the central clearing and margining requirements, this is the large substantial part of Emir which hasn't yet been implemented. So if we look forward to this on a timeline basis, we see that we're probably on a time basis perhaps about halfway through, with already time confirmations, dispute resolution, portfolio reconciliation and compression already in place. On the reporting perspective, went live on the 12th of February, and then the 13th of May was the deadline for reporting existing trades which were live on the 12th of Feb, because there was a 90-day window in which to report those. So on the reporting perspective, the next key deadline is the 11th of August for collateral and valuation reporting. As regarding the clearing obligation, really the first of that has really kicked underway on the 18th of March when the first EU CCP was authorised. This then will kick off various other obligations for ESMA to draft, and ESMA still has to draft the reporting technical standards associated with mandatory clearing. So we are therefore still a bit uncertain on some dates as to when the first clearing obligation could actually come into play, and then following that we're expecting the obligation in relation to collateral holding for OTC uncleared trades to come in at a later date, again possibly around Q4 2015, but still there's further work to do on that. So I'll move on now and focus on the Emir reporting sets. Now that we're live on Emir reporting, there's sort of two things that are very, very likely to happen. The first is issues around data quality are soon going to become apparent, if they're not already in some cases. And the next one is FCs and NFC pluses have to be building and planning for their valuation collateral reporting. So we'll consider the data quality issue first. By now, everybody should be reporting their new trades on a D+1 basis and should have reported the population of trades that were already pre-existing on the 12th of February, but live on the 12th of February. I think if you talk to anybody in reporting, they will agree that just about the biggest issue is UTIs. This was seen in advance this was going to be an issue, and it has continued to be an issue. So there's still issues about the assignment of UTIs to existing populations, with people trying to share them. Agreements then on who generates the UTI on new trades that are executed and going forward. And of course, ESMA issued their UTI guidance on the day before go live, and to date, nobody, with the go live and managing post go live project, nobody really has really started to look at that yet. So that will have to be looked at. Moving outside UTIs, we also have the question of the inter-trade repository reconciliation. So ESMA expects the repositories to be reconciling the trades with each other if they're not held within the same repository. And the repositories, obviously, clearly this is a very, very challenging task for the repositories to develop and do. Their focus for day one was having a working repository that clients could send trades to. Now they've got to work on the inter-TR reconciliation, which means that each repository has to first try and look for the other side, to the other report of the trade within their own repository, and if it isn't, they've then got to share those orphan UTIs with the other repositories while they all try to locate the other side of the UTI. Clearly they are still working on this, and therefore the information available and the quality of their reconciliations to date isn't in a position where market participants can start to figure out how they're going to handle the results of this. And then finally, we're in a position that regulators, as yet, are not really in a position to be actively looking at the trade data that they're receiving on a daily basis from the trade repositories. So moving on next to consider what are the actions which people might be considering about in relation to data quality. Certainly resolution of UTI issues. People will need to develop a process to check they have UTIs on all trades and to consider their approach on how are they going to manage the UTI differences due to different trade booking approaches. Because there's, it's not an uncommon situation that because people have different trading systems and different approaches to managing trades, one side of the trade may have one booking for a trade with one UTI, their counterparty may have three bookings with three UTIs. And if therefore there is a difference in expectation on the number of UTIs in the trade. It's not seen as that realistically we're going to move to a uniform global way of booking all trades, so people will have to develop their own approach of how to manage those UTI differences, because ultimately everyone needs to get a UTI in the trade. Participants are also going to have to think about how they're going to manage the results of the inter-TR reconciliation. Because there's also a reconciliation of some of the trade data, some of the differences that can arise out of that reconciliation aren't actually due to actually real differences in the trade, but really just differences in how to represent something, maybe how to describe an underlier, or a very common difference is the execution date and time. What's the execution date can match. If it was a trade that's not executed centrally on a platform, but say is being booked manually, then people's execution time will not resolve down to the same second, but the inter-TR reconciliation could be doing it down to seconds. So there'll be a lot of differences due to differences in execution time. Over time, people will have to start to think about how they're going to respond to regulators on the regulators' feedback on data quality and consistency. The experience for Dodd-Frank in the US was that it takes some time for the regulator to look at the data and start to identify where they think of the data quality issues. They may do this on an asset class basis, so in some cases it can be more than a year before really there's feedback from regulators on where they have issues with data quality or representation or consistency. Also, finally, for companies who aren't reporting themselves but have asked their counterparty to report on their behalf, they may have to consider, do they want to put processes in place to try and confirm that their counterparty has reported the trade and what their counterparty has actually reported. So that's the data quality based on the reporting which is already in process now. Move on next to the valuation collateral. Now this is an obligation solely on FCs and NFC pluses to report just on a daily basis. What are obligation only on FCs, so financial counterparties, and NFC pluses, non-financial counterparties who are above the clearing threshold, that they must report a daily valuation on and collateral posted. So the valuation and collateral must be reported on a T+1 basis. The collateral must be reported by the party that's posting the collateral. Now, one of the things that's been recognised is that collateral trades aren't necessarily collateralised on a trade basis, but quite often it's on a counterparty basis. So parties can actually report collateral on a portfolio basis. However, if they're going to do this, their individual trade reporting needs to be updated to reflect the basis that they're reporting on a portfolio basis, which means that, say, the FC will allocate a portfolio code to a particular collateral portfolio, and then that portfolio code must be reported to the repositories against the relevant UTIs, so that the regulator can identify which UTIs belong to which collateral portfolio and then see the collateral which is actually posted. The valuation, though, is done on a trade basis and has to be done on a daily basis. Obviously, at the moment, the trade repositories are in the process of developing the reporting specifications. Obviously, whilst this is happening, as is always the case once these things actually come to implementation, there's been a lot of questions asked around the industry, which moves us on to the next actions aspect. So at the moment now, the industry and through their trade associations are engaging with ESMA to clarify the details of the valuation and collateral reporting. So many aspects like do interest payments get paid, how a haircut's handled, etc. Participants are actively developing at the moment to do this, including updating their trade reporting functionality to be able to report the collateral portfolio code on the relevant trades where they collateralise on a portfolio basis. Obviously, another question is for parties, companies who are using reporting on behalf of services where their counterparty is reporting on their behalf, you know, they may also have to look and see if their counterparties can report collateral and valuation on their behalf as well. There has been quite a few questions about, say, Party A reporting valuation on behalf of Party B, because Party A doesn't have Party B's valuation of the trade, and obviously two parties to a trade don't necessarily have exactly the same valuation. So this is one of the big discussion points with ESMA and the national regulators, is if one party is reporting on behalf of the other, can they use their own valuation? Because obviously receiving a daily valuation from your counterparty is operationally a very, very difficult task to implement. So that's where we stand now with respect to Emir and the next steps there. So I'm going to move on now to the final area, which is the Emir clearing and collateral. So this forms the really final elements of Emir implementation, and we can split it into three areas. One is CCP authorization, so that's central counterparty authorization. Second part is mandatory clearing, and the third bit is OTC collateral. So the CCP authorization is already underway. So this is clearing houses who want to offer CCP services must be authorized under Emir. If they're an EU-based firm, they must be authorized by their national regulators, and if they're non-EU based, then they must be authorized by ESMA. To date, we had the first authorization on the 18th of March, which was NASDAQ, and 3 more have been authorized since then. Clearly, there's still a lot in the process. And when a CCP, a clearinghouse, is authorized as a CCP, they're also authorized for certain products as well. Between them, so far, those clearinghouses have been authorized for product scope show. That doesn't mean that every clearinghouse is authorised for each of those product scopes, but between them they cover all of those. That becomes important when we move on to the mandatory clearing obligation. Now this applies to FCs and NFC pluses, where if a product has been defined by ESMA as subject to mandatory clearing, then when those parties trade that product with each other OTC, they must clear it. ESMA has not yet defined any products that will be subject to mandatory clearing. They will be doing that, they're in the process of doing that now, and they're doing it on a clearinghouse basis, so we don't yet know which those products will be. It won't be that every product that a CCP is authorised to clear is subject to mandatory clearing, because ESMA has to assess it also in terms of the liquidity of the product, the costs of clearing, etc., because it's going to mandate people to clear that product. What is very good for companies is that there are intragroup exemptions from the clearing obligation, which companies can apply for if they meet the required standards that are set out. And the very last part of mandatory clearing here, which is probably a very key one to cover, is the front-loading obligation. And what this means is that existing OTC contracts and trades can be subject to the clearing obligation, even though at the time you executed the trade, that product wasn't yet subject to mandatory clearing. And that's because the clearing obligation is tied back to the date of the CCP authorization, not to the date at which the product became approved for mandatory clearing. Clearly, this leaves people in a very big place of uncertainty, not knowing if they're doing trades now, which they may have to subsequently clear in the future when they're partway through the trade. And there's been some discussion between ESMA, communication between ESMA and the European Commission specifically around how to handle this front-load obligation and potentially looking at staggering it. So that brings us to the very last part, which is OTC collateral. And again, as part of the risk mitigation, this applies to FCs and FC pluses, and it applies to collateral on the uncleared OTC trades to make sure that they are managing their risks. There's a regulatory technical standard that has yet to be drafted to implement this, and that's currently going through the drafting process at the moment. So between the three of them, those three key areas make up the Emir clearing and collateral obligations, which will be the final paving stone put in place for the implementation of Emir. So that was my end there. So I don't know if anybody has any questions.
Thank you very much, Colette. Yeah, there's a few that have come through. So the first one that came through is, have regulators provided any feedback on trade reporting?
No, there doesn't seem to be any really in-depth feedback that we've heard about so far. I think regulators have, they didn't really have any data to work with till the reporting went live and the trade repository started feeding it through to them. So whilst they may have had structures of reports, they didn't really know what populated data would look like. So to date, there's been some sort of very high-level feedback, but they haven't really got to grips with it yet.
Okay, fine. And can a firm's counterparty report collateral and valuation on a firm's behalf?
Yes, they can. The open issue here is around the valuation. If party A is reporting for their counterparty, party B, can party A use their own valuation for party B? And that's one of the areas which is with discussion. Because clearly if party B hasn't set themselves up for trade reporting already, to commence doing their own valuations might be a bit difficult.
Okay, fine. And then there's another question. Will NFC companies have to clear trades?
At the moment, based on what's drafted, no, we don't think that NFC counterparties will have to clear trades.
Okay, fine. So thank you very much. Just to all the attendees, if there are any other questions, then please do fire them through now or forever hold your peace. But in the meantime, Collette, thank you very much for that. Very insightful. It doesn't look like there's any other questions being asked or sent through, so we'll end it there. Let everyone go home for the evening. Thank you again, and look forward to speaking to you soon.